Okay, so as an employer, someone who hires someone, whether you're hiring them technically as an independent contractor, employee, what have you run a business, you operate a business, or you manage one, and you're facing some potential legal issues. Is this something that you should do on your own? Um, it really depends on the type of issue. So if you've been sued, so if you've gotten served with a summons and complaint, a petition, something like that, by a process server, and they've served you, you have a limited time to respond. So it's very important that you do, or even regulatory agencies will have response times or hearings that are set on a very short time frame. So you need to make sure that if you have been served with something, that you pay attention to any time frames in there to file any kind of response or respond or show up for a hearing. Um, and generally, you're probably going to be better off, and especially if you are a corporation or an LLC in most states, you probably have to have, by state rule or different procedural rules, have to have an attorney represent you. You can't, as the CEO or even like the general counsel, attorney of the company of a corporation. In some cases, some states, you're not allowed to represent the corporation. You have to hire independent attorney to represent you. So in those cases, most of the time you're going to have to hire an attorney. It's going to be 150 to $600 an hour, depending on your location, pay some kind of upfront retainer for them to represent you in court. And it really depends on the type of case, how long it'll take, how much it'll cost total. But most of the time, you're going to have to hire someone to represent you. Representing yourself as an employer in court is going to be really difficult to keep up with timelines, any kind of local rules, procedures, state law on whatever the claims are. If it's a wrongful termination, something your employee is saying that you've done wrong. If it's a creditor coming after you for money, you might be able to file some kind of response or work out a deal with them and a settlement. Always put it in writing. Whatever the settlement is, that they'll dismiss any case and waive any future case. So anytime you're settling any kind of employment law, whether it's even a breach of contract for money that you owe as a company or an employer, you always want to get something in writing, a settlement and mutual release, or at least a one-way release, saying that number one, they release you of any potential, claims that they could bring. They dismiss any pending lawsuit, and they waive any, they agree not to sue you, a covenant not to sue in the future, um, in exchange for whatever settlement you're going to make. So if you're going to pay them something, you want to make sure you get something in return. And that's also with your employees. State laws vary. They may not allow you, and federal law too, depending on the type of employee, what they're doing, what state. You may not be able to get a mutual release of certain types of claims. Those may not be claims that can be waived. So just be aware that even if you settle with an employee and you put in your settlement agreement, hey, you waive all potential claims. Some cases, like a workers' comp in California, is something that may not be able to be waived necessarily. So they could potentially later bring a workers' comp claim. That's just one example. So just understand that. And any other cases, issues that come up as an employer, usually you just pay somebody hourly as an attorney, employment law attorney, usually is the type of person you want to talk to. If it's an issue that could go to litigation or is in litigation, meaning a case has been filed, you might have an insurance policy that covers, at least covers that or covers the defense. So look at your insurance policies because they may cover you as the employer. They may exclude certain types of claims, but I would look at your policy, talk to your insurance broker, see whether you want to make a claim if against some insurance that you have, because if you do, they may take up the defense, they may hire the attorneys, they may take care of everything for you. So that's something that's important to look into first to see whether you have insurance coverage that would cover your legal fees. Any other issues that come up, most of them are very specific depending on what the employee brings up, whether it's an injury at work or wrongful termination or wage and hour, failing to pay overtime, um, breach of an employment contract. Usually it's an employment law attorney that represents defendants or employers. is the person you're going to be looking for to talk to, at least get a consultation. I would say most of the time you're probably going to end up having to pay somebody something because number one, you probably can't represent yourself in court if you're a corporation or an LLC. And number two, it's a lot of these are very technical issues and can add up based on state law. A lot of times there could be penalties and fines if you're not doing something properly. So you want to get some good advice on, did I do something wrong? Do I have a valid defense here? And then from there, you can decide whether you want to spend money on potentially trying to resolve the issue or even trying to offer something to try to settle the case and just avoid it altogether. So generally, any kind of employer issues that come up, usually you're going to end up hiring an attorney for that.